That's right.
This isn't about you. It's not about you.
That is correct.
Stop right now.
Good afternoon, Your Honor. Nicole Sadi. I represent Ms. Henderson, and she is now at the podium to my right.
Me?
Nicole Henderson.
All right. I've received the assessment. Have the parties had an opportunity to
People have, Your Honor.
I have.
Go ahead. Any additional argument?
I'm sorry, I didn't hear the last few.
Any additional argument regarding her release?
Yes. Would you like me to go first?
Sure. It doesn't matter.
Okay. So, Your Honor, I see that Ms. Henderson was extremely forthcoming with Mr. Statman during this assessment. While I'm looking at Ms. recommendation, these recommendations Statman are making include abstinence as well as outpatient treatment. I'm also looking at the law enforcement bond information form that I'm showing Mr. Cook right now. Thank you. Let the record reflect I showed it to him. Looks as though the police, the day that she was arrested, considering everything that they saw on the scene, was recommending a personal recognizance bond along with the scram tether. My client is willing to wear the tether as she understands this is normally a usual part of bond on a matter like this, as well as engage in AA. I understand that upon reading this report, it may put to somebody's mind, well, Ms. Henderson has been to rehab before. And in terms of the actual nature of addiction and rehab, Your Honor, I would argue that that is what we see when people are breaking a habit. There is a recommendation in here that is something she has not done before. Ms. Henderson has not attended Alcoholics Anonymous before and had that type of support and ability to make some sober connections. She has never done that before. And it looks as if Mr. Statman believes, professional assessment, that she would be a good candidate to go ahead and receive outpatient treatment combined with these other recommendations.
At this point, the defense changes its strategy. Instead of arguing about the criminal charges, the lawyer focuses on the main question in a bond hearing. Can Ms. Henderson be safely released under certain conditions? Notice that the lawyer keeps pointing to the professional assessment instead of simply asking the judge to trust Henderson. That matters because judges usually rely more on expert evaluations than on promises made in court. The defense also offers several safety measures, including outpatient treatment, Alcoholics Anonymous meetings, and a scram alcohol monitoring ankle bracelet. These are meant to lower the risk of future problems, not to prove Henderson is innocent. The lawyer also openly admits that Henderson has struggled with alcohol instead of trying to hide it. This can make the defense seem more honest because it recognizes the judge's concerns while presenting a clear treatment plan. The big question is whether the judge will believe these conditions are enough to protect the public, or if the seriousness of the case will outweigh the proposed safeguards. At this stage, the hearing is less about punishment and more about managing risk, ensuring accountability, and deciding whether supervised release is a better option than keeping Henderson in jail.
You're having just two brief things. One, just a slight correction from what was just indicated about the information form. Where I believe the council looking, that was the people's original recommendation at the time of charging something we pulled out, not the police. Certainly that was the charging EPA's recommendation in the case, and when the case was first brought before this court, I asked for more than a PR bond for the reasons I indicated on the record. I know that doesn't factor into the court's decision today, but I just wanted to correct that. The second matter the second piece that I wanted to discuss was in my review of the defendant's version of events as told to Mr. Statman, that they differ from what I believe the report and the evidence shows, not too dramatically, but in ways that I think it's important for the court to be aware of. Specifically, one part in the first paragraph indicates that the defendant completed field sobriety. She was only able to complete one of the three tests, to my understanding. The other two were not conducted or completed due to the defendant's lack of cooperation at that point. Admittedly, as the court's aware, she was incredibly intoxicated, so I'll just attribute that to her recollection of the event might not be the best. I don't think there was any malice on her part. But I think it's important for the court to have that corrected understanding.
I would like to respond. I will say that this is a paraphrase, and I would also like to say that
Why,
Henderson.
can I ask why you're going down the path that you're going down?
Yes, that he's paraphrasing that Mr.
But why are you,
Paraphrase.
why does, go ahead.
Okay, there may be an inconsistency here, but that doesn't mean there's an intention to be inconsistent, is where I am going down this road. I think you understand. I don't go further. The other thing I did want to address for this court's attention is while Ms. Henderson acknowledges what the blood draw was, this blood draw was taken well over 4 hours after the initial arrest where blood alcohol rises. So it is not an indication of where her level was at the time of arrest.
So we're going to argue over those points?
Your Honor, in the bond argument we're making based on this report, I'm bringing forward based on science
Good.
for my client to pursue.
Why do you think I asked for the assessment, counsel? Really? Why do you think I asked for the assessment?
Well, Your Honor, my job's to advocate for her.
And it'd be good if you did that, but why do you think I asked for the assessment?
I can only go by what you said. I'm not in your mind, but you said that you were concerned about my client's health. You're concerned about my client's mental health. You're concerned about her relationship with substances. And I believe you ordered the assessment because you wanted to be informed on those concerns before considering reducing bond. That's my belief.
Why can't I get arguments that go toward that?
This, in my opinion, this does go towards that. When we're looking at blood draw this high, the science shows, and
You know what? I mean, I'll let you go. I'm going to do what I want to do because I've been trying to get Miss Henderson out. I've been trying to do it in a safe way. I've been trying to do it with as many safeguards as I possibly can get. Trying not to miss anything. That's what I'm trying to do. I don't know that the arguments you're giving me help me any way in that.
Your Honor, respectfully,
That means I'm going to get none. So go ahead.
Your Honor, that is extremely unfair. And on the record last time, you said something that was unfair as well.
You know what? This ain't about you.
That's right.
This isn't about you.
That's
It's
right.
not about you.
That is correct.
Stop right now. Deputy, take her back into lockup. Court's going to stand in brief recess. All right. Yeah.
This part of the hearing shows one of the most important moments in the courtroom. Judge Simpson keeps trying to bring everyone back to the real purpose of the bond hearing, deciding what treatment Henderson needs and whether she can be safely released. Instead, the lawyers spend time arguing about blood alcohol levels and other facts that the judge had already said were not the main issue right now. The tension grows when the defense lawyer says the judge is being unfair. But judges have the authority to control what is discussed during a hearing, especially if they think the arguments are moving away from the legal issue. Did you notice how Judge Simpson kept asking, "Why do you think I asked for the assessment?" He wasn't just making a point. He was reminding everyone that the bond decision should be based on the assessment, not on arguments about the evidence. Even though the judge seemed frustrated, nothing suggested that he had already decided to deny bond. He simply wanted the hearing to stay focused. The short break in the hearing also shows how judges sometimes pause proceedings to calm things down before making an important decision.
Fine. Like, rub my temples. Court recalls the case of People versus Anderson.
Good afternoon again, Your Honor. Raymond Cook for the people.
Good afternoon, Nicole Sadi, opposite, and my client is standing to my right.
I'm going to dispense with any further argument, if that's what we want to call it. What I'm going to do is defendant's going to be released on a personal recognizance $25,000 bond. Prior to release, she must be placed on a scram tether. So, ma'am, you won't get released right away, but they'll come and fit you with a scram tether, and then you'll be released. I'm going to order as a condition of her bond, you're programming through, because you're employed at GM, right?
Yes.
And so I'm going to indicate also that the defendant is to engage with, is that GM or UAW program?
Well, it's called Rivers Bend, so I'm not.
It's called what?
Rivers Bend, the IOP program.
It's through GM.
Can I say something?
Hang on a second. I'll do it this way. That you're to engage with General Motors Employee Assistance Program, whatever their program is. You wanted to say something?
Yes. During my assessment today with Matt Statman, I had told him that I wouldn't mind. I would like to do the Dawn Farms program. That's $40 a week outpatient.
Here's what, so that we know. This assessment gives me one sort of side of view. All right. The Employee Assistance Program, I want you to engage with GM's Employee Assistance Program because it's available to you. Okay. I'll indicate that you're also to engage in Dawn Farm programming. I'll make that a condition of your bond, but I understand if one program is there, that might be a bit much. But okay, so I'll make that also part of the order. And then, is there anything else from either side on?
Nothing from the people.
May we briefly approach, Your Honor?
Yes.
Thank you. Yeah, shall be done. That's
Back. Teachers are. Oh, because it shows my face scrunch. Just if we have a quick in chambers.
I think we're doing it, sure.
Okay. All right. We're all set.
Thank you.
Thank you.
You're welcome.
The judge's final decision shows that bond hearings are about balancing public safety with rehabilitation, not deciding whether someone is guilty or innocent. In the end, Judge Simpson approved a personal recognizance bond, but he added several strict conditions. Henderson must wear a Scram alcohol monitoring bracelet, take part in her employer's assistance program, and attend the Dawn Farm outpatient treatment program. These conditions directly address the concerns raised in the professional assessment. Another important detail, is that the judge wanted Henderson to use the treatment resources already available through her job before looking for other options. This shows a practical approach that encourages compliance and reduces the chance of future problems. Even though there was a heated disagreement between the judge and the defense lawyer earlier, it did not decide the final outcome. The judge kept the courtroom conflict separate from the legal decision and focused on what the law required. What do you think? Did the defense lawyer's arguments make a difference? Or was the professional assessment the biggest factor in the judge's decision? And would the result have been different if those treatment recommendations had not been available? If you enjoyed this courtroom breakdown, don't forget to like the video, share your opinion in the comments, and subscribe for more real courtroom cases and legal analysis.